Welcome, Ben. Thank you for taking the time on a busy Wednesday to tune in and provide some information.
Good to be here.
How's your week going so far? How has this crisis affected you?
Personally or professionally? Personally, I'm catching up on a lot of Netflix, I think, at night while we're working away. And professionally, we're just dealing with the kind of the ebbs and flows of the client demands right now. So as you can imagine, we've got some clients that are experiencing, some challenges with respect to, their lenders and their commercial landlords and that kind of thing. And then we've got other clients that are seeing this as an opportunity to, re-examine their businesses and in some instances, their presence across Canada. And it's been interesting, that's for sure. But so far, we're seeing people working together and a lot of knowledge sharing, which is part of, I guess, what we're doing today.
So obviously in the current situation, a lot of entrepreneurs and business owners are seeing themselves in a cash crunch. A lot of people have lost the majority of their business. So during these times with suppliers and vendors, obviously a lot of them are in contracts and agreements where they might have to pay out cash but don't have cash coming in. So from a legal aspect, what kind of options do you suggest people look at, and what advice do you have for them for managing those things?
Good question. Generally speaking, as you mentioned there, almost all of the clients that we deal with are having to take a look at, what their obligations are. I do highly suggest that if you do own, a small to medium-sized business, as soon as possible, if you haven't already done so, dust off those agreements, look at what's in them. The best advice I can give you, and selfishly, is to contact legal counsel as early as you can, just to get a sense of where your risk lies and what your obligations are. Even if it's just a quick call with counsel to kind of go through what you're dealing with. We found that that's been really useful in terms of proactively addressing issues that can be dealt with when they're 1 out of 10, but if it gets to 8, 9, 10 out of 10, sometimes it limits your options in the back end. So definitely do reach out to your counsel as soon as you're able to. And generally speaking, as I mentioned at the outset of the call, people are whether it's our guys or our clients' landlords or vendors or supply chain partners, people are working together. So, before things boil over, definitely call, on a without prejudice basis and have those discussions with your, landlords, partners, vendors, and get a sense of what their situation is before going down the road of potentially litigation or anything like that. It's definitely good to have a conversation with the other side, because we are finding that people are working together to, whether it's abatement of rent for commercial landlords, from commercial landlords to the benefit of the tenants, or whether it's deals that have conditional steps that need to be taken in a timely manner. We're pushing those out, and we are seeing a great number of individuals working together in order to avoid potential downside in terms of litigation or complications that way. So have that conversation for sure, and as I mentioned before, make sure that your counsel is sort of in that conversation, even if as an observer of what what the conversations are, so that he or she can advise you in terms of what your obligations are relative to what you may be asking for in terms of an easing up of your obligations, or like I said, on the side of some of the commercial landlords that we represent, if you're going to be easing up, whether it's abatement of rent or just asking your tenants to pay out costs or whatever it is, make sure that you're taking a look at what those commitments mean immediately and then long term. And generally speaking, if there's going to be any amendments to any agreements, make sure that those amendments are in writing and express the intention of the parties because you may find down the road that that complications pop up, notwithstanding everybody's desire to do the right thing, that in a time of crisis like this, any waivers or agreements should be documented appropriately to make sure that you're not having to revisit everything later on down the road as well.
Yeah, that makes a lot of sense. So what advice do you have when that conversation does get a little bit more difficult? Like if you have a provider and you're stuck in an agreement with them and it's kind of make or break for the business and they aren't giving you any leeway outside of, are there any steps before just talking to your lawyer?
Like a rock and a hard place kind of situation where you have to make a tough decision. For sure you want to be talking to your counsel in that case, and for sure you want to be going through the agreements that are in place. Every situation is going to be different. Every situation is going to turn on the black letter of the agreements, and then any common law rules that sort of govern that relationship. I'll just maybe, if it's all right, I'll just touch on a couple of the main questions that seem to be coming up from the client side and sort of have been discussed kind of in the boulevard with respect to agreements, whether they be a commercial lease or a service agreement or anything like that. We're getting a lot of questions around force majeure clauses and those fire and brimstone aspects of agreements to say, what happens when everything goes wrong. So maybe I'll just touch on that quickly, just kind of define what that is and what that means to the parties. So if a force majeure clause basically is a clause in an agreement, could be, like I said, a lease agreement, could be a service agreement, whatever. But essentially, it says that if everything goes wrong, and act of God, pandemic. But essentially, what it's saying is if this agreement is impossible to perform, then and each clause will be different depending on who's drafted it and what's included. But in the event that one party seeks to rely on a force majeure clause, they're basically saying we can't do this agreement anymore. So obviously a lot of event companies right now are experiencing this because concerts simply can't take place. But we're also seeing, like I said, commercial tenants seeking to rely on it. But the starting point there is whether or not you have a force majeure clause in your contract, and not every contract will have one. And then whether or not the situation fits within it. It's likely that the courts will be seeing this as an unforeseeable situation. There's some precedent to sort of indicate in other jurisdictions back, with SARS way back, that was the courts didn't really directly comment on it, as far as I understand, but there was some indication that was seen as an unforeseeable event, and this does kind of carry the same tone with it. So if you've got a force majeure clause, the starting point is take a look at it. What's in there? What circumstances can you rely on that? Unfortunately, in commercial leases, it's mostly going to be to the benefit of the landlord, not the tenant. But in normal service-based agreements, you may find that there's a provision that benefits both parties that says, either party can rely on this provision if the terms of the contract become impossible. And that's the key word there, is impossible. So if it becomes slightly more difficult or more onerous or more costly, typically you can't rely on those provisions. Now, if there is no force majeure provision, if you go to the document, you don't see one, that's not really where you stop. So going beyond that, there's also the contractual concept of frustration that parties are looking to rely upon. So in that circumstance, similar to force majeure, if there's no force majeure clause, the party still might say, hey, listen, we just can't perform this agreement. It's just impossible to perform. And so one party might seek to remove themselves from that arrangement by saying, this contract's completely frustrated. We've got to back away, and we've got to be released from our obligations. Obviously there's still the concept of mitigation in terms of the damages that are associated with it, and mitigation in terms of mitigation in terms of your obligations under the agreement. You have to make sure that you're attempting to perform the agreement, that that it truly is a situation where it's completely just untenable for both parties to continue. So those are sort of the two sort of heads of or instruments that some clients and other parties are taking a look at right now to say, if this is just a complete non-starter situation, there's nothing we can do here. We can't put 50,000 people in a stadium tomorrow, kind of thing. What do we do? And a lot of them are landing on one of those two concepts.
That makes a lot of sense. Do you think this is going to affect how agreements are drafted in the future? Do you think this is going to have a big effect on a lot of those things and make long-term changes?
I think a lot of lessons are being learned right now in terms of risk. And I think a lot of, for good or bad, I think a lot of businesses are now realizing that, those 40, 50 page, 100 page documents that they, may or may not have reviewed in detail really do, over a long enough timeline, impact your business. And I think we're seeing a lot of clients that are benefiting from that. If they've had, good paper in place and they've had the ability to review that, those provisions and those concepts in the context of their business. And we're seeing some clients that are, coming to us saying, hey, listen, this was in place 10 years ago and I didn't have a lawyer then, and I downloaded it off the internet or something like that, and they're really realizing that notwithstanding all the other demands of a small to medium-sized business, having good paperwork in place definitely, for those that have it right now, it's definitely saving them in terms of being able to rely on these provisions if they have to, but also in terms of just the parties understanding what their relationship is, and not having any gray areas there, because really that's where we're seeing when things do degrade in terms of negotiating during this time. It's when the parties, the understanding is completely different from either side, and they're just too far apart to even come together and negotiate. So I do think there's going to be a lot of lessons learned, but I mean, to be quite direct with you, I mean, SARS wasn't that long ago, and a lot of lessons were immediately so touted as being lessons that we were going to learn go forward, but unfortunately that just doesn't seem to be the case. So I do think that a lot of businesses right now are, especially in Alberta, are feeling that crunch, and I do think that. Some guys are going to come out of this a little gun shy, and some guys are going to come out of this, better for the experience in terms of knowing their business in greater detail and knowing who they're working with, right?
Yeah, we've had a lot of conversations in the past few months here about the importance of contracts and having them done properly for a big range of things. What advice do you have? And obviously, this is a difficult question to answer broadly, but what advice do you have for business owners when they are selecting a lawyer to work with, to make sure that that person has the expertise to get the corporate paperwork done properly?
Well, so lawyer is a broad umbrella, and there's some aspects of the practice of law that are very niche, and there's some that are very broad. Generally speaking, when it comes to and I think our audience here is mostly kind of small to medium-sized enterprises, but when it comes to paperwork, employment agreements, commercial leases, that kind of thing, any lawyer in the province of Alberta, that indicates that they practice in this area is usually fairly capable of processing those kinds of documents. I think where clients get into some trouble is, when you're a startup, you don't have a lot of cash. You're being mindful of costs, and sometimes you'll you may not have a lawyer even review the document or whatever, and that's kind of more so where we're finding some challenges. It's not that a lawyer has reviewed it and was not capable of doing the job. It's that the lawyer potentially didn't even see it until they're dusting the thing off and reviewing it for the first time with the client. But it really depends on what your matter is. Obviously, if you're looking at a situation where you're having to review a commercial lease, I mean, that kind of has one footprint in the corporate side and then one footprint on the litigation side. So every business owner, gets a sense of who they want to work with on the legal side of things. And we take a team-based approach to this. I think that, if I'm giving general advice to small to medium-sized businesses in terms of who they want their lawyer to be, and selfishly here, I'm obviously biased, but I think you want a lawyer that not only understands their job but understands your business. It makes for better paperwork. It makes for a better understanding in terms of what expectations are in terms of cost and risk and all that kind of stuff. But if you're working with a lawyer that understands 50 feet away, but understands what your business is, what's important to you, what your intentions are in the next 5, 10, 15 years, that goes a long way. So find a lawyer that likes your business, basically, and is willing to kind of dig into the nuts and bolts of your machine.
Awesome. That's really good advice. So I was talking with somebody and they mentioned that they heard that it's going to be something close to 30% of small businesses are going to be eliminated throughout this thing. And I think that's probably a very high, massively exaggerated number. But how big of an impact do you think this is going to be on the small business community, since you probably have a little bit closer connection to that community and maybe a better idea of what the repercussions or the impact of this is going to be? Like,
a lot of my advice on this would be kind of anecdotal. You want to talk to an economist probably, or somebody that's capable of giving you sort of the ripple effect of because we're really experiencing the immediate effects of this right now, right? People can't make their mortgage payments. People can't, make their whatever, they can't pay their suppliers, that kind of thing. They've had to lay off employees. They may not be able to rehire those employees when this sort of turns around. But I think the ripple effect of what we're seeing right now will be quite broad, and I think that we're hearing that from our government. We're getting some stimulus, some injections. I think that the changes that have been made are positive in terms of what they're doing for small businesses. But to your point there, I just think right now it's not enough. So one thing I will say, to small and medium-sized businesses is get a hold of your lenders right now. We're seeing lenders, I won't kind of favor one over the other, but we are seeing lenders definitely stepping up and getting financing in place really quickly, like getting stuff in and out of credit in 24 to 48 hours in some cases. And that's allowing our guys to weather this storm. And even if you have to lay off employees, if you still have financial obligations that are ongoing, it creates a bit of a buffer there that you can kind of absorb in order to keep the lights on. So I would suggest that even if you're not feeling the hard kink in the hose right now, is get in front of your lenders, whether you're working with the Treasury branch or a major institution or credit union. Talk to them now, and make sure that you're having that conversation, that you're talking to your accountants in particular, because if you do need access to credit, know that they're going to be asking you for financials. They're going to be asking you to go through maybe your personal financials as well. So to the extent that you have time to do that now, definitely get that housekeeping tightened up so that if and when you need to move quickly, you've got that stuff already in place.
Yeah, that's really good advice. I hope that it doesn't come to absolutely needing that to survive for a lot of business owners, but I'm sure it's to a degree already there for some of them.
Yeah, and just going back to what I was saying earlier, call your landlord, call your supplier, and have that conversation with them, because I think what's happening for some businesses right now is they're because that can be potentially an adversarial conversation or an uncomfortable situation. They're not having the conversation until they're the needle's way into the red. So I encourage you, this is not a legal recommendation, but I encourage you to, once you've had a chance to speak to somebody that can advise you on what paperwork you have in place, reach out and say, hey, listen, this is our situation. And for the most part, I mean, I can't put a hard number on it, but probably about 80 or 90% of the conversations we've had over the last 2 or 3 weeks here have been positive outcomes. And we found a way to work with the other party in terms of getting a sense of what the actual agreement is and maybe amending that for 6 or 8 months or whatever until our guys can get back on their feet. But have that conversation now, even in an informal way, and you'll probably find that creates a dialogue that will benefit you if you need to pivot quickly.
Awesome. That's really good advice. Do you have anything else to add before we wrap up here, Ben? Anything that you think business owners out there should be aware of, or what kind of clients or things can you help business owners with?
Well, generally speaking, we're sort of full tilt here, everything under the sun. So it's challenging stuff and it's exciting stuff that we're processing for our clients. And it'll differ from client to client and lawyer to lawyer. But I would invite you, if you to the extent that you have questions, reach out to your counsel. Most of us, we're a peer regulated organization, and most of us know that we have to kind of step up here and support each other and support our clients through these challenges. And I can tell you, I get probably 30 or 40 calls a day, and they might be a minute or they might be 15 minutes, but I'm happy to take those calls and address those concerns from the client side. And I think that again goes a long way in terms of getting some clarity with respect to what's happening and what the impacts of whatever the situation is that they're encountering. But it gets more information in front of them. So I would suggest that, to the extent that you need to call your lawyer, your accountant, or any other advisor, have those phone calls now, because it's going to be the well-informed small to medium-sized business owner that's going to come out of this hopefully a stronger organization, but come out of this relatively unscathed, in my opinion.
Yeah. Awesome. Well, thank you, Ben. I appreciate it. And thanks for taking the time today in your very busy week.
Yeah, no, anytime. Happy to be here.
All right. Talk to you later.
Okay, take care.